Also, Christina Cameron is here tonight. She's the assistant in my office. She's going to be going through the CAM training as well, and going forward, she'll be attending the monthly board meetings so that she can get that back in knowledge about what's going on with that. So those are just a few things from me.
We're going to take new business item A, and have the representative from Councilman Garfinkel. Sorry, I'm reverting back to
We can't send
way back in the day. Present his proposal for assessments. Thank you for coming.
So much. Oh, I'm so happy to be here.
So where did you travel from?
Florida. Yes. I have some things prepared for you. I appreciate your time very much to see us today. I want you all to know as a board we conducted a pretty thorough investigation of your situation. I have these books to provide to you. Now the information in these books is confidential. Some of the information that I've seen from the manager on your present situation. I will speak as freely as possible, but some things we probably have to talk to you about not in open session. This is mine.
No, I have one of those.
Yeah, that's
These are different. Sorry, I'm filling you with information, but a little different. Some things are a little different. You're very welcome. Okay.
And if you'll mic at the podium.
Absolutely.
You may position at the podium as needed.
You're going to have to get pretty close to that mic to work.
How's that? Okay.
Whoa.
Sorry. You know what? Can I just speak without the mic? Can you all hear
can, I
me?
think yes.
Okay, I'm much more
Can
comfortable.
you hear them?
Not very well.
Okay. I feel like breaking into song while I use this. Okay. My name is Lee Katzman. The firm is Katzman Garfinkel. We are a full-service community association law firm. We've been practicing association law for 20 years. I've given you a lot of information in front of you. Some of the information that you have in the binder, in the very front of the binder, you'll find a couple of letters that I've provided for you. Those letters basically provide our thoughts on what we can do for the association, our different model that we have that we think very well suits your association's present situation as far as delinquent accounts are concerned. The no cost, no fee guarantee is something that only our law firm is offering in the state of Florida, probably in the whole country. And it's basically an ambitious opportunity for an association like yours where you have lower assessments, and maybe you don't want to pursue those assessments timely because the exposure to potential legal fees and costs, if the account doesn't end up favorably for you, could basically be more than the amount you're going to collect. So what our no cost, no fee model does is that it basically takes all of the risk and burden financially off of your association and puts it back onto our law firm. So in essence, we've had an opportunity. Is this working well or is it not really working?
Not very, it is an echo.
Okay, I'm going to speak a little louder. Can everybody hear me now?
Yes.
Okay, I'm sorry. Okay, so what basically our model does is we've handled more delinquent accounts for associations in the state of Florida than any other law firm in the state. We have two offices basically in Florida that are our main offices. One is in Fort Lauderdale, which is the South office, and one in Orlando. We're very interested in helping you with your situation. We don't believe it's a very problematic situation to solve. I think the biggest issue with your delinquencies as they exist is that you haven't pursued them. You haven't actually had somebody pursue the people who are not paying you, and therefore, without asking people to pay or demanding they pay, they typically will not pay. The process of delinquent account collection is very standard. It's a demand letter, a lien, a foreclosure of that lien, a default or a judgment, and then a potential sale. We believe that once lots of your owners are notified by a law firm like ours that they owe money, that they'll settle their accounts up in the beginning part of the process, which will not be burdensome to them. Some people may take further along the line in order to resolve the account, but we believe that we can resolve the bulk, at least over 50% of your accounts, we think, before the foreclosure process. The biggest problem you have is that nobody's attending to it, and that's the most important thing. The model that we have now is very suitable for you because as long as we do our job, no matter what happens, if we're unable to collect the debt because the bank forecloses before we get to the courthouse steps, because it's a tax deed sale, because it's a bankruptcy or any other issue where you would normally be presented with a bill, we basically eat that bill for the attorney's fees and costs. So we would make efforts to collect the money that you're owed against the membership that isn't paying you. And if we get the money in, we basically take our attorney's fees and costs, which become part and parcel of the debt that's owed by the owner. We also keep the interest and late fees on that file that we collect upon, and we send you 100% of your maintenance that's owed. So we believe that you'll be able to actually be a great benefit this year because you can collect a large bulk of this money that you haven't collected over the last 3 or 4 years. In addition, I know you just levied another assessment coming due in January. It's really a matter of keeping that momentum going and making sure your ownership understands that isn't paying you, that they need to pay you. Now, that being said, you're a community, okay? So this is a business, which you have the obligation to run as a business, but it's also a business of neighbors. So understand, our ambition is not to take your residents' homes. We do not want to do that. What we want to do is we want your residents to pay for their fair share of what they enjoy that the association provides to them. I always equate it to like a potluck dinner. You know, if I'm having a potluck dinner in my house, and the only requirement is you got to bring a dish. If you want to come in and eat everybody's food, then you got to bring a dish. But if you show up at my door and you say I want to come in and eat everybody else's food without a dish, that's not really fair. Okay? So we're not looking to cause injury to your membership. We're looking to work with them. To that extent, if we have owners that truly have a hardship and cannot pay us all at once as we demand, we will be happy to offer them payment plans. Okay? Payment plans will not be for a year or 18 months or 24 months. They will be for 6 months, most likely, at the most amount that we offer somebody. If they have exigent circumstances, if they've lost somebody, if they've lost employment, or there's really reason that we can give them an extended payment plan where it won't jeopardize our ability to collect the money that's owed to you and to the law firm, we'll be happy to do that. Okay? So I don't want you to think that we're predatory in any way. We will really solve your problem. I believe that by addressing the ones you have now, where you're owed, I don't want to bring out numbers, but you're owed a good amount of money, okay, from the owners. We believe that our pursuing those matters in conjunction with making sure that year over year, from February, in the middle of March, whatever it is, 60 days past the due date, we pursue the owners who don't pay, you'll actually be able to have a more funded budget. Now what does that mean to you? Well, every year you have bad debt that you put in your budget because you expect to not receive money. So therefore your budget is actually inflated unnecessarily. Because if you actually budgeted what you needed, which you do, and you obtain payment on, let's say, 98% of those amounts, then you can actually keep your budget thinner. But your entire membership is actually paying more money because of the debt you're carrying. It's important to address the debt. One of the other things that's important is that you're coming close to the time where if you don't address it, it may expose you to potentially not being able to collect it down the road with respect to legalities and statute of limitations and these types of different issues. So in that book I gave you, I prepared for each of the board members, it's a little bit of history as far as what your budgets look like, and I can tell you that Ms. Salazar was very helpful in giving me information that I could do my job and really come to you today with information as far as what I thought about it. Because for me to put out literally, most likely hundreds of thousands of dollars from our law firm in filing fees and service of process potentially, and fees that we generate in doing the work that we do on behalf of your association, I have to make sure that we feel comfortable we can do the job for you the right way. And based on what I saw, I really don't see any issue with that. If you look in the back of the book, you'll see there's an official records search. One is by date and one is by type. The same document, but they're two different search protocols. If you go to the one that's by type, what that is basically is I went on public records, and I'm very big on crossing T's, dotting I's, and making sure everything is the way it should be. So I went on public records and did a search on Holley by the Sea to see all the activity that your association had in the last 4 years. And that gives me an idea of, well, what is out there, what's happened in the association. So we see several bank foreclosures, we see some changes of title, but we see that really the only action that's been taken, there's been about 80 bank foreclosures where they took title back on properties in Holley by the Sea in the last 4 years, okay? That's not inordinate. It's actually low based upon the number of units you have and homes you have in Holley by the Sea. So that is a good indication that by us going forward with collection efforts, we're not going to see owners being foreclosed upon. We believe that we're going to see owners paying what they owe. Additionally, since the amounts that are owed to Holley by the Sea are not grand, now some of the amounts are between, let's say, $400 and $2,000 or $2,500. The benefit you have is that these amounts, while they're not, $20, they're not $10,000, $15,000, $20,000, where an owner basically is unable to pay because they have a hole for themselves they can't get out. So we believe that by offering some payment plans potentially, by working with your members to get them to pay what they owe, we believe we can effectuate the back due money that you're owed. Now, if we do that, we believe that we'll collect 80% of your money without any problem, okay? If we're able to collect 80% of your money, what you need to remember is that whatever your delinquency is at this point in time from the prior years, and you take 80% of that money and put it onto your 2016 annual budget, you'll be good financially. Because you'll take more that you're owed and then add it to the budgetary, what you expect for this year, okay? And then also we can help you make sure that 2016 delinquency will not be where it was in prior years by just addressing it. Now, everything I'm talking to you about, what we will do at no cost and expense to you. Now, how does that make sense, okay, from your standpoint? Well, by handling 25,000 accounts like this over the last 2 decades, we understand how things work in this arena. Now, I can tell you that we're a law firm. We're AV rated. We're one of the firms in the state that people do look to as far as association issues. We represent over 500 associations in the state of Florida. We have about 50 staff members right now, and we're very good at what we do, and we're accurate in what we do. We run teams of paralegals and attorneys. We're not going to be billing your homeowners for efforts that aren't necessary. We're going to be billing them for our work, which is demand letters, liens, foreclosures, okay? That's basically where we are with the situation with delinquency, okay? There was one thing I wanted to tell you. I gave your manager a book that you don't have because I basically downloaded all the information for her on the ownership of every single home in the entire subdivision. And I also downloaded, if you look at the back of that book, April, there's a tab called Taxes, which is really interesting, which I don't know if you know about. But April and whoever else has been working has been very good about paying the taxes, except there are about 50 parcels in your association. And these are small pieces of land that your association owns. And the bills are being sent to a different location. Who's that? Do you know who that is, that location?
Yes, Belly Waves.
Okay. All of those parcels are delinquent. I don't know if you know that or not. You do know. Okay. So what I've done is I've taken the liberty, for your information, to print out every single one of those tax bills, every single one of those parcel descriptions, and it's complete itemization in there of how much is owed in each parcel and what you have to do. And I can help April along with making sure that she does what needs to be done. But that needs to be taken care of because I've seen a lot of associations lose those little parcels and then have people buy them and come back and hold them up with a gun in their back, basically saying, give me X amount of dollars or I'm not going to give you property back. And it could present problems. So I wanted to bring that to your attention as well. Overall, we believe that the model that we have well suits your association. We think we can bring the money in that you're owed, I'm telling you without a doubt about 80% of it, pretty quickly, because we don't think that your owners are going to fight us that much because of the amounts that are due, plus the fact that we think a lot of the reason why they haven't paid is because they haven't been maybe asked past the point of the manager or the management company asking them. If people get a letter from a lawyer, or they tells them the lien's been placed on their property, or tells them they have a lien that may be foreclosed, the level of attention to that issue, it definitely shines a light on it. And people generally will, make amends and do what they need to do to get you compensated and us compensated for our efforts. Do any of you have any questions thus far? Yes?
So, just with the payment, this is just an arbitrary number.
Yes.
If we have $250,000 and it again, it's just arbitrary, it's just a number. $250,000 in delinquent payments. Of that $250,000, what are you paid?
Only the late fees and the interest on the accounts I can collect.
So
Everything
if
else
you,
goes
if
to
you can't collect the interest and the late fee, but we can collect the assessment,
Oh, well, that won't happen. I mean, owners are gonna either, when we make a demand against the owner, we'll be demanding the amount they owe you in maintenance, the interest, the late fee, and the attorney's fees and costs we incur. Those are all part and parcel of the debt, pursuant to your governing documents, and that's what we need to collect them.
so the owner is paying your attorney.
That's correct.
In addition to the late fee and.
That's correct.
Now, would that make it more difficult for them to pay, since not only are they paying the late assessment, or the assessment, but also the late fee interest, and then you've got the attorney fees, would that make it more difficult for them to pay that?
Of course it would. Only to the extent that more money is more difficult to pay than less money.
Can you give me an example of what the attorney fee would be?
Sure, absolutely. We have a spreadsheet. We do a lot of the things that we do on a flat fee basis. So the demand letter, I believe, is about $175, the demand letter. It goes out by certified mail, regular mail, and there's opening file fee, which comes out to be about $200 for the demand process. In an HOA, it requires 45 days notice to the owner, basically telling them they owe this money. They have 45 days to pay the debt. If they don't pay it or contact us, then they will obviously have a lien placed against their property, okay? Now, we do a lot of things that are kind of interesting. We have status reports that are online, which I can't really show you today, but it's very comprehensive, the system, so you'll be able to track every single account that we're working on and see exactly what we're doing with each account. Additionally, when owners are sent the demand letter, it notifies them that we wish to resolve their debt with them, and it directs them to a website that we maintain on behalf of the owners, where they can communicate with us directly. So a lot of times, a letter will go out, and people will get home from work, and they will receive this letter, and they want to do something about it, okay? But we're closed, so for 24 hours. So we direct them to a website called contactthefirm.com. And that's a website where they can go on, they can navigate the website, and they can notify us that they'd like to speak to us, they'd like to receive an estoppel letter, they'd like to make a payment plan, whatever it is. And I think I gave information about that in the information I gave you. So you can check those sites out and see how that works as well. But again, the important thing is that you want to collect the money that are owed from your membership that aren't paying you. Additionally, if you don't make any effort to collect it, then year over year, those however many accounts are not paying you will not pay you again for this year and will not pay you again for next year. So it's sort of like the membership is aware that they have 5 bills to pay, but maybe they can only pay 4 at the time that the bills come in. Well, right now, everybody at Holley by the Sea sort of understands that if they don't pay your bill, nothing's going to really happen to them, because there hasn't been any action or demand made against them for several years. So the idea is that your membership needs to understand that if they don't pay your bill, then there's going to be potential ramifications to that, which are in the form of attorney's fees and costs, and potentially can go down a further path. We do give everybody an opportunity to settle when they do it. We send a demand letter out, and they call us up, and they want to make a payment. They can make the payment right in the demand letter, and they'll be paying what they owe to you for however many years, plus the interest late fees and the attorney fees incurred at $200. And everybody has that option.
So, for say example, 12, 13, and 14, if you had an individual who was late those 3 years, would they be charged 3 separate attorney fees, or would it be
Oh, no.
just?
It's the total debt.
Okay.
We're seeking to collect against each owner what their account statement shows they're deficient.
So that $200, for example, would cover those 3 years?
Yes, it doesn't matter if I'm going to collect $27,000 on behalf of a client or $200 on behalf of a client. The demand process is the same. It's a regular and certified mail letter addressed to the owner or the owners at multiple addresses, last known in the association records, plus any addresses I find on public records, and the demand is the same. It's the same place.
And how successful have you been for an association such as ours, where you come in and we've got, like this quantity, if you will, what's the success rate at collecting these?
Well, again, the interesting thing about your association is we believe we're going to be exceedingly successful in your association, because there's 2 things that are important. Number 1 is the size of the assessment. If people didn't pay in your association for 3 years, and the assessment was $3,000 a year, and I had to collect $10,000 from each owner, I'd have much more concern about that, because that's going to be difficult for people to pay. You know, sometimes you have the money, sometimes you don't. But since the assessment is lower, we believe that we'll be more successful. In debt collection, it's relatively simple rule. Smaller debts are usually collected from larger debts. So the smaller the debt, the more probable it is to be paid. The larger the debt, obviously, the adverse of that. So that's number one. The amount of the overall debt, even people who haven't paid for 3 years, is still around the $1,200 to $1,500 range, which we think is very reasonable. And as I said, if we need to give them a payment plan for a couple of months, our goal is to get you paid and get us paid and have the owner current with their account. That's our goal. So that's number one, why we think we'll be successful. Number two is the fact that we think that a lot of people don't pay until they really have to. You have a lot of things you have to do in your life, okay? I know I have to clean my garage out. And I know that I haven't done it, and I say, oh, I'll do it next weekend, next weekend. But until something happens where I need the space in the garage, now I need my space in the garage, right? Now, all of a sudden, it's front of mind. Now I need to go clean my garage out, if that example does anything for you. You haven't really told your membership, you need to pay us now, okay? So we believe that once we go ahead and do that, that we will have a great success in people paying their amounts that are owed. Whether it's right up front, paying it in a lump sum, or paying it over a few months, whatever they need. Okay?
Now, our current
Yes.
timeline that we use is the assessments are due January 1, and they become deficient or late at February 1.
Yes, sir.
What kind of timeline do y'all look at as far as when you pick up the ball and start running with it? Is it 2 months down the road, 3 months down the road, 6 months down the road?
Right. So on this model, basically, we only accept this model for new accounts. So normally, if I came into an association like yours that isn't yours, and they said, you know what, I have 40 accounts that I want to turn over to you, but they're 3 years old, I wouldn't take them. Because the risk is difficult for me. Because understand, in the end, whatever I would normally bill you is going to be my problem, not yours. So what we do with this model is that it's really only utilized for a new accounts going forward. But why is that? Because I don't know what's happening with the bank foreclosures potentially that are existing on those accounts. It's typically a race to the courthouse steps. The bank first mortgage is superior to the interest of the association. Okay? So even if I get to the courthouse steps and the property gets auctioned off, if nobody buys it, goes upside down, and it goes back to the association, then I have an opportunity to sell the property for 30 days. But we basically work off a 60-day. Now, we are offering to your association 2 main things. Number one is to accept all of your older accounts under our new model of no risk, as long as they're not in bank foreclosure. Okay? There are some that are in bank foreclosure, but we could look at those a little more closely and see whether it makes sense for us to go down the path. Because even if they're in bank foreclosure, doesn't mean that people aren't going to pay. Just because you're in foreclosure doesn't mean that you don't resolve, you don't, reinstate your mortgage or resolve it that way. So I will look at each file independently and make sure that it's something that we feel comfortable with on my behalf and your behalf. But based upon the only 80 transfers of title in the last 4 years where the banks actually proceeded and took title back, we feel kind of comfortable based on the number of units in your association that we shouldn't have a problem with that. On a going forward basis, we'd like to receive the 2016 accounts by no later than February 28th, the end of the month. We think that gives sufficient time for the managers to send a letter saying, your payment was due on the 1st, it's late, please send payment in, and in the event that you don't send payment in by this date, we're going to unfortunately have to turn it over to the attorney for collection. Okay? So that gives plenty of time. If you want to put a notice in your, if you have a newsletter that you do or anything like that, you put a notice in saying that you retain counsel, that you're taking seriously the obligations of the association membership to pay their dues, so that everybody can enjoy the benefits derived by the association, and that you're going to take a little bit more of an aggressive stance on delinquencies going forward from this year forward. And I think that you'll alleviate your problem. You won't have a problem. In an association like yours, typically you can look at a 3% delinquency rate. That's going to be standard across the board. So you're never going to get down to the level of 0. People always have, they go on vacation, they have different things. Things happen in the world. So a 3% delinquency rate would be very acceptable, but the 3% delinquency rate in your association with 4,700 units is still 150 delinquencies a year, which can be resolved rather easily and quickly. But our goal would be to cut 80% of that money that's owed to you. I would venture to say that I would get 80% of the money owed to you in the first 9 months without a problem. I think more will come in on the front end though, than on the back end. It's not really a problem in our minds, as far as what we've seen and what we've done in the past, we don't believe it's an issue where you're gonna be out your money. You're not.
How are other debts that are owed the association handled, and are they included in this? I know we're talking about assessments, but we're in the process of possibly setting up a fining process where if we incur a fine on a member and that fine is not paid, will that also become part of that total debt owned by or owed by the member that would be picked up by you in your organization?
Okay, it's an excellent question, Kevin. Fines are a little bit more complicated. Now, that being said, the legislature had previously, many years ago, allowed HOAs to lien for fines, okay? And then it was taken out of the statute where the HOAs could not lien for fines. And then it was put back in the statute where you can lien for fines, okay? I am not a fan of liening for fines, and I'll tell you why. There's different types of fining issues and violations by owners, okay? We have something that I've offered you in that package also. It's called it's our name I gave it many years ago, but it's called the fast track violation process, okay? And what that basically is, we've offered your association to provide your manager and management team with certain forms that will satisfy prerequisites to filing lawsuits against owners. Because remember, a fine, it has to go through a process. You have to have an independent committee, not related to the board. They have to meet. The owner has to get noticed by certified mail. They have to have a hearing. They have to hear the owner. They have to make a determination. They have to fine the owner. Send the determination back to the owner by certified mail. Make sure they received it. And then what happens? Then you ask them to pay the fine. What is not happening in that entire time frame is the violation is not being cured, which is the main purpose of why you fine. You don't fine to get money. You fine to get compliance. Okay? So what we do is we don't necessarily think the fining process is applicable to all of your violation problems. And I don't know what your violation issues are, but you would tell me. You would say, Lee, generally our violations fall into 10 different categories, and these are the 10 things we violate for, okay? What we will do is prepare a letter that we will give to your manager. 10 different letters with those 10 different violations, where she or he can plug and play the information with the owners and send that letter to the owners. What that letter basically says is, the documents say you can't do this. This is what you're doing, that is why you're in violation. We're demanding your immediate compliance to comply and cease this violation within X amount of days. If you don't do that, and you don't believe that you're in violation, and you wish to subject yourself to a mediation, we're offering you the opportunity to mediate. Here's a list of mediators that we like to use. Pick one if you want to mediate, and give us a check for half of the fee that's associated with mediation. If you fail to give us that check, we're going to assume that you don't want to have mediation. In the event that you don't cure the violation, we're going to immediately file a lawsuit against you. Now, what does that do? What that does is that empowers your association to not waste your time, go through a process that could expose you to liability, and instead gives you an opportunity to basically notify the owner of their violation and get them to cure it without any expense from me, from the lawyer. Now, some of them might go to the next level, but I would be confident to tell you that 90% of the violations that you exist with right now, if I were to give you those forms and you were to utilize them, you'd solve 90% of them, 95% of them, at no expense. Number one, you wouldn't put any money out. Number two, you'd be solving your violations, which will benefit your community and your neighbors of people who are violating. So there are ways that we have to do those things, that we've been doing this a long time. So fining is applicable in certain circumstances. Certain things that people are doing. Their landscaping isn't up to par. You also probably in your documents, and I haven't reviewed them that carefully, but you probably have something called a correct and bill, which is basically, it says that if an owner fails to maintain their property in the standards that are needed or determined by the association governing documents, that you as an association have the right to go on the property after notice and effectuate the repair and then bill them back on their ledger, not as a fine, but as an individual assessment against their property, which can be liened for and then collected that way through the foreclosure process. But as far as fines go through a fining committee, I don't like liening for those things because ultimately you get before a judge. What happens is the judge, there's 20 checks that they have to make sure everything was done exactly right. And I'll tell you, when I get before a judge, let's say even that it was done and we get the violation cured, but they haven't paid the fine. So now you say, well, what do we do, Lee? They cured the violation, but the fine hasn't been paid for $1,000. And I say, well, I wouldn't recommend going to court. I would waive the fine. You say, we don't waive the fine. That's a bad message. We go in front of the judge. Judge says, counsel, what are you here for today? Here on a violation matter, Your Honor. Well, what are you seeking? We're seeking the fine to be paid. Well, is the violation still outstanding? No, it's not. So the violation's been cured, counsel. Yes, it has. But you're here in front of me today and you're seeking how much money? Well, now, Judge, we're seeking $1,800. $1,000 for the fine, $300 for the filing fee, $400 for the lawyer's appearance today. So the judge says, well, so you want me to enter a judgment against this owner for the violation, for the fine, when it's been cured, and you now have it for $1,800. The judges hate it. And they will find any way possible to throw you out of their courtroom. And then, instead of being out zero, if you would have waived $1,000, now you have attorney fees and cost expense, which you don't want to have. Okay? So when you focus on the violation, you're focusing on curing that violation. So there are times where fines would be applicable, and there are times where they would not be applicable. That's part of a more in-depth conversation for us to have about what the violations actually are and how to deal with them. Now, you know I traveled here from Fort Lauderdale today, and I want to thank you for inviting me because I've never been to the bar before. And it reminds me a lot of upstate New York. I don't know if any of you are from the Northeast, but upstate New York, I was in Binghamton and Albany for lots of years. I went to school, and it's very comfortable. And I also have the feeling when I'm here, like I do on the West Coast, where there's not a buzz in the air. In Fort Lauderdale and South Florida and Miami, it seems like there's always hustle and bustle. When I go to Naples or Sanibel, it's very calm and quiet. Even when I came here tonight, it was nice and calm and quiet. So, one of the things we've offered to you, because it was a long time for me to get here today, two planes and a car and the whole deal, but I'm happy to be here. So one of the things we've offered you also, if you were to retain us as counsel, and allow us to work with you in your association to your benefit and our benefit, would be a video conferencing unit. And what that basically is just like the TV you have behind you. But we can install that anywhere you like, and should we need to have a meeting or a conversation, I prefer to do things face to face. The phone is okay for me, in person is the best, but we video conference between our two offices for the last 10 years, the Orlando office and the Fort Lauderdale office. Every day we use the system. And basically it's two 42-inch, 50-inch screens, along with a video conferencing unit. You need to get a data line, which is basically a Comcast line or whoever else provides cable services here for DSL or for internet, and you can see each other like you're sitting in the same room. And it's a wonderful opportunity for you to have and your management team to have to access to us in both of our offices for our entire staff whenever you like. We will consult with you as much as you like free of charge on that video conferencing unit. We'll be happy to talk on the phone if you want free of charge. You'll all have my cell phone number to ask me any questions, but we really look at it as a relationship. You know, we want to be part of your community. We want to help your manager and help your board and make all your lives a little bit easier. Because we have knowledge in one very small area, which is association law, and it's something that I'm very passionate about and have done for a very long time. So we wanted to really give you a lot of information. I'm sorry if it's too much information, but I wanted to show you as a board and as management how passionate we are about what we do and come prepared to the meeting so that we could give you something before you tell us whether you want to work with us or not. And I think that's important. And I think you already knew what I found. When I found it, I thought it was something that was impactful and that you didn't know about possibly, and I was happy to find it for you. But that's about it, I think. As far as what you want to do from this point going forward, if you have any questions, if you want to talk on the phone, if you want to discuss things in the future, we're available. We're very excited potentially to work with you in your association. Yes, sir.
Just quick. So I going back to your fee
yes,
structure and things
yes.
like that. So things that we have been accounting for, like assessment revenue, or interest revenue and late fee revenue under facet, that basically from our budgetary side would be gone.
Yes.
And we'd be able to where, I think we're probably still gonna have a line item of bad debt, will we not?
Well, the idea would be like this. I want you to understand that we would be, in essence, taking your late fees and interest because of the age of these accounts. The age of these accounts make them more exposing of our potential to not collect the money, okay? On the going forward model that you have in front of you is really not a big deal for associations because interest and late fees aren't revenue sources. Interest and late fees, just like fines are made to compel compliance. Interest and late fees are penalties to compel payment, okay? Interest and late fees and fines should never be viewed as sources of revenue for the association. It should be viewed as tools that you use in order to keep people in compliance with the governing documents and to keep the flow of money coming into the association. So while you're correct in saying that, yes, if I pursue those accounts, I'll be advancing time and money out of my law firm. We have multi-million-dollar lines of credit. I've had lines of credit as high as over $10.25 million. My line of credit now is at $4 million. That's what I need. Excuse me, right now it was 6, it was 8, it was 10. But as the volume of cases that we handle go down, we need less money to advance on behalf of our clients and behalf of our firm. So the answer is yes. I would be taking the late fees and the interest that you have on your books for those old accounts. But in return for that late fee and interest that I would be taking upon successful completion of an account, you would never be exposed to the legal bill for fees and costs that I incur on pursuing that debt for your association.
And we'd be able to show a lower bad debt.
Oh, right, that was your question, I'm sorry. So the bad debt, what was your bad debt this year? Do you know in your budget?
About 56,000.
56,000, okay. So the question is, if you were using a figure hypothetically of $250,000, okay, that you're owed. You don't know what that's maybe a total figure, but you don't know year over year what that amount is. So let's say that $56,000 was the amount year over year that you're owed, your shortfall. And the bad debt line item for that budgetary year, $56,000, was 100% of the amount that you think you wouldn't collect, okay? If I tell you that this year in 2016, I'm gonna collect 80% of that $56,000, I don't know who to do the math, but it's at least 44,000 of that 56. So if I did that, and in essence you didn't shortfall the 56, next year your bad debt line item could be 12. So in essence, your overall budget, unless you need money or reallocate your funds in different areas, could potentially be much more sad. Now I don't know based upon what your needs are, or based upon your delinquency, what you have gone without, so to say. I'm not a proponent of potentially lowering maintenance assessments, because that's very quickly forgotten. You know, a lot of associations say, you haven't raised our rates for 7 years, and then whether you raise the rate $1 or $7 or $100, there's gonna be the same amount of yelling, okay? But I can tell you that any business is more well run when you're not financially strapped, whether that's a not-for-profit corporation or a for-profit corporation. Another thing I learned the other day that's really interesting is that of all of the for-profit corporations in the United States, the majority of them gross less than $50,000 a year. Okay. So understanding that we talk about the association as a business, but a business of neighbors, most associations in the state of Florida are larger than most for-profit corporations in the United States from a business standpoint. So you're definitely running a business. The question is, you have to have a little bit of the TLC when you're understanding your business is a business of people and neighbors. So on the one hand, you're fiduciarily bound to enforce your governing documents and to compel payment and compel compliance. On the other hand, we live in the real world where we have people that experience different things in life and have problems from time to time. We want to work with them as well. The key is to create the balance between the two and to effectuate your goals in the least offensive manner against your membership, the least expensive manner for your association, and the best way to make your job easier as volunteer board members and management to run the association to the satisfaction of people who live here. But we all serve the same people, and it's the people that are in the room. You also being those people. Just because you're a board member doesn't mean you're not a member anymore. So whatever decisions you make, obviously you also have to succumb to those decisions as well. But our law firm, this is what we do. I'm very passionate about working with people and creating personal relationships. And you know, I hope that answered the question that you asked. Okay. Does anybody else have any questions for me? I traveled a great way to answer your questions.
There's one in the audience.
Sure, yes, sir.
Can I ask about
Anything you like, sir, yeah.
hypothetically, Ms. Harper said hypotheticals earlier in the meeting, and I just had one. As an example,
Yes,
you send a letter out.
yes.
You get a response to your firm from a homeowner. The response is, look, my father has cancer, my son just got a DUI. I can't pay you X, but I can pay you Y.
Okay.
How would the firm handle something like that?
Okay, so one of the things we have to do, did everybody hear the question? Okay, so the question is basically somebody sends a letter back, we demand, let's say, $1,200, the person hasn't paid for the last 2-3 years. The letter comes back saying, you know, I've incurred some hardships, my father has cancer, he's living with me, I'm taking care of him, I lost my job, whatever it is that people have hardships. As I stated before, we'd be happy to work with that person so long as a few things aren't going to happen. Number one is if they're not presently in bank foreclosure and a bank foreclosure is filed, we can't allow a payment plan to that owner. Because now we're jeopardizing the money that's owed to the association, and I'm jeopardizing the money that's owed to my law firm for our efforts, okay? So as long as there's no bank foreclosure, can we work with the owner? Absolutely. What would we offer the owner? Well, as I said before, we're not a bank. My law firm's not a bank, and the association's not a bank. But, truthfully, that owner, for whatever reasons are going on in their life, has, in fact, used the association as their bank. Because they paid other debts that they have to pay. Because if FBL didn't get paid for a month, the lights go out, okay? So they benefited from not paying the association. So we have to find the balance. So the balance that I would tell you would be is that we would be able to offer that member a 6-month payment plan, where they can pay the amounts that they owe equally over 6 months until their account's current. But it's going to be in writing, it's going to lay out what they owe, it's going to lay out what the charges are, they're going to acknowledge the debt, because if they break that agreement, then we're going to proceed forward and use that agreement as evidence that they basically can't contest the foreclosure action because they've already admitted to the debt, okay? But we'd offer them a 6-month payment plan. Now, if they came back and said to us, well, we can't pay it in 6 months, we need a year, I will tell you that I do not think that we'd be comfortable doing that, based upon the size of the debt and the fact that we're not a bank. Everybody has problems, and everybody goes through life. And I can tell you that in every type of association, whether the homes are $50,000, $500,000, $5 million, or $50 million, there are people that are just situated in those associations that cannot afford to live in those associations anymore. They just can't. That's the reality of life. People have good times, they buy bigger houses. Everybody in this country expresses themselves in a way where they take a little bit more than they can possibly afford. That's just the way it works, okay? So the answer to that question is, we understand it's a business, we understand it's a business of neighbors, we want to protect our fees, we want to protect the association's amounts that are owed to them. So while we will work with owners to get them to pay what they owe, we will not be unreasonable by not offering a payment plan, and we will not be foolish by offering one that would expose our law firm and the association to financial loss. Does that answer your question? Okay. Anybody else? Yes, sir.
Yeah, it's been a couple, 3 years since I've been on the board. You're touching on it. When I was on the board, we went with a number of not a number, 2 or 3 members that went to the mediation process. You're
On
saying
violations or collections?
collections.
Okay, sure.
One was both, but mostly on collections.
Right.
And we had a good faith mediation and worked it out. You were saying if you're to go to mediation in accordance with 720 as it's required to be offered, that there would be no waiver of money. Just the only thing you go to mediation over would be an extended payment plan.
Well, a few things I want to clarify. 720 requires that mediation is offered for a violation, not for a collection. Okay? There's no obligation to mediate a collection matter.
That's in their location.
Okay. But there's nothing wrong with a mediation. A mediation really occurs more when there's a dispute over the parties' situations. I'm hopeful that the financial records that your association has maintained over the last several years are accurate, and I believe they are. I don't have reason to believe they aren't. But if I went to mediation, would I waive some attorney's fees? Would I waive some interest and late fees to sell the account? You betcha. Of course. But I'm not going to tell you that I'm going to do that as force and conduct.
Right.
I'm going to tell you that if I feel the association's position is jeopardized, if I feel that my position is jeopardized, if I feel I can serve the needs of the association by getting the account settled, look, you know, because understand something from our standpoint, we go to mediation. In the end, if I can't settle the account, I go before a judge. And a judge has the right to determine what my reasonable attorney's fees and costs are in the end. In the end, when I'm sitting there as a big bad law firm that's pursuing owners in the association who may have issues like the gentleman in the back said, and go to the judge and say, Judge, I have these problems, please, 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 the judge has no problem striking a portion of my costs and striking a portion of my fees. Okay? So I understand the realities of what's going to happen at the end of the road. So I could potentially, by waiving even a little bit here and there, making something happen and settle, create benefit for myself and for the association and for the owner.
Yeah, I'm just keeping in mind, and I don't know if this particular case is still out there, and I won't mention names. But we had multiple, at least one, if not two, legal rulings of amounts awarded to the association.
Right.
The person still wouldn't pay.
Well,
And
yeah.
at that point, during the foreclosure action,
Right.
I believe mediation was still required.
Typically, a judge, depending upon if you're filing in county court or state court or circuit court, again, two different things. Foreclosure actions are cases of equity, which means that it involves the home, it involves people's property, and it can be brought in either jurisdiction. Typically, you have dollar amounts and value. If it's under $5,000, it's got to be in county court. If it's over $15,000, it's got to be in circuit court. Okay, but you can actually bring a claim that's less than jurisdictional amounts for circuit court in circuit court if it's a case of equity. So that's a lot of information you probably need to know. In any event, those types of issues, as far as mediation goes, most court judges, especially in county court, will like to see the parties mediate prior to it getting to them because they think that they can be worked out. And both parties understand that it's their last opportunity to resolve the issue prior to the court making a determination that could hurt either one or the other. But it's not a requirement.
But if it goes to that route,
Yep.
your offer still stands. It would be no additional cost to the association.
My offer stands with the association that you will not be receiving a bill. There's only 2 times, and your manager wanted to make it very clear to you what times you'll be receiving a bill from me, okay? Now, we're talking about as far as the work today is the delinquent account collection work. So, you'll never receive a bill from me on delinquent account collection work unless 2 things happen, okay? Unless, number 1, your information is wrong that you give me, okay? I have to rely upon your financial records. I didn't maintain it, and I don't know if it's accurate or not. All that you do is you're giving me a document saying, this person owes this much money, and go get it, okay? And that's fine. But if there's a situation where, for some reason, that amount is wrong, now if the amount's not exactly right, but if they say, we don't owe you money, you paid us, or we have checks that show that these checks were cash, but they were never applied to our account, okay? That could, in essence, compromise our ability to collect our fees and costs. Now, will we still try to resolve the account? Obviously. If there's still money owed and there's discrepancy, we'll adjust the ledger and we'll tell them, okay, your amount you owe is now X, not Y, okay? Not a problem. But if that compromised financial record disables me from doing my job and collecting the money, I would send you a bill for my time, okay? That's number 1. Number 2 is that I'm going to be investing a lot of time and a lot of money into your cases, okay? So you need to let me finish what I start. Now, the agreement I sent to you says basically that you can terminate the agreement with me anytime you like, okay? All that means is I'm not going to take new cases on. And as long as we don't have a huge problem with each other, even if you terminate my services for going forward, I will finish up the cases that you give me, okay? But if you say to me, Lee, we want all of our cases back, we want you to stop doing your work, you're going to have to owe me the money. Because I'm putting out costs, and it will be in the hundreds of thousands of dollars for me to do this work for you. Maybe less, because I'm thinking that most people will settle up sooner in the process rather than later, which is great for everybody. It's great for the owner, it's great for you, and it's great for us. We want to solve your problems. We want to have you as a client for many years to come. So we would like to work with you not only in the capacity of delinquent account collection and potentially violations, but all of your needs and issues. That's what we want, and that's what we like, is long-term relationships. Does that answer your question, sir?
I believe so.
Okay.
How long are you going to be?
As long as you like. I'm leaving tomorrow at 10 o'clock in the morning. Stay as long as you like. Yeah. I have nowhere to go but here.
Okay, because we won't make a decision tonight.
That's fine.
We vote on issues on Thursday.
It's not, I've been around 20 years, it's not a rush for me. I'm just excited because I know that this new model for me is a new toy for me, pretty much. I always have to be the leader in what I do. I am the leader now as far as what I offer. I offer full advancement of all attorney fees and costs throughout the entire process. Very few law firms in the state offer that. I've been offering that for 18 years, okay? This is the next step in that process. Not only will I fully advance all the fees and costs, but I'll assume all the risk going forward. So I understand where the market is today, I understand where the real estate market is today, I understand where the values are. I'm an economics major from undergraduate. I understand the business of what I do. So I understand that I can make money and change the way lawyers work with associations on this. There's an article, an ad that I put in one of those in the paper package I gave you, which is going to be in the journal that I'm advertising. It basically is, I'm challenging every other law firm in the state that does what I do to offer what I offer. None of them will. None of them will because they think like lawyers, don't like businessmen. And they're adverse to risk. We not only do this kind of work, we do full service work. We handle casualty claims. We brought in over $100 million for our clients handling casualty claims through 2004, 2005 on full contingency. If we didn't win, we didn't get paid. We do construction defect claims that are larger, more than $1 million. We have construction defect claims that we've handled that are worth $20, $30 million. We brought in over $20 million on settlement on construction defect claims. Full contingency. We advanced $7 million in fees and $2 million in costs in the case. We invested, risked that if we didn't win, we wouldn't get paid. But we won, we got paid. So we're not averse to thinking a little bit more out of the box than other people think. So for us, and for me, I want to not only be first, I want to be way ahead of things. I want to offer what other people don't want to offer or can't offer. So you can ask whatever lawyer or law firm you want to interview if they will match this, and they will not. They will not. Because they don't have the, in South Florida, the bank that loaned me over $10 million never loaned a law firm more money than loaned my law firm on line of credit, ever. We pay the money back, no problems with it. So we know what we're doing in this arena. Don't ask me about anything else. But in this, I know what to do and I can help you. And we would love to have a relationship. Okay?
All right, if it's okay with the board, I'm gonna, we can take a break for 5 minutes so we can.
I'm sorry for being so long.
It's okay, you're from the Northeast, I understand.
I'm usually fast. I spoke slowly tonight. I spoke much slower than I usually do. Everybody yells at me, including the court reporters, about slowing down my speaking.
Well, I'd like can we take a break for 5 minutes and then we can see him out? All right, so what's the proper procedure, just break? All right, make a motion to take a time. When we get to that in the new item, or new business, so committee reports? Okay? Yes. Yes.
The,
No, it's good. The architectural committee.
I'm Bob Hutchison, the new chairman for the Architectural Control Committee. Mentioned violations here. New violations that happened during 2015 was 890. Those that were resolved during that same period, 990. The outstanding violations, if I'm reading this, the date is 1917.
There are 1917 outstanding.
Correct, if I'm reading this correctly.
Do you know how long the time period?
I'm sorry?
Do you know how long that time period is?
Not on this, I don't have it, it just goes back to December 14th. So some of those could be from past years, yes, correct. And the other thing I don't have here is what specific stage they are in at this current time. So I do know that there's obviously several of them that are out there that are in various stages. But if you need a more detailed report, let me know. Any questions on those? There is one other thing I'd like to bring up rather. It is a rezoning issue. In accordance to the Holley by the Sea Consolidated Covenant, page 19 of 33 as of 14 April 2008, lots 2 through 12 on block 109 are listed as multifamily residential structures or commercial structures. We are in receipt of notification from the county that as of 8 August 2015, they have rezoned that as to 1R, which means single family residences.
Now, where are those lots located at? Just
On
in a map.
399.
Okay, those are the ones that are actually on 399?
Correct. Correct. And this R1 is permitted the use of single family dwellings and modular homes. Also permitted are necessary buildings such as garages and sheds. So I just bring that up because this is kind of lingering out there, and if we take it before the ACC, it's going to be, and then back up to the BOD, it's going to be next month. So like I said, this has been hanging out there since about August. So we just want to try and get this expedited to either agree to go ahead and change the covenants to reflect the zone 1.
Well, we can't change the covenants. All we can do is enforce the covenants based on the current law.
Okay.
Which if the county zones it R1, then we'll just have to treat it as R1.
Okay.
We'll still be able to enforce restriction on modular.
Okay.
But as far as commercial and multifamily, if they're just zoned as R1, then we'll have to treat it as such.
Okay.
Oh, and I think that's the issue is that we had been talking about is when the county comes back and they state something like this, which is in conflict with what our covenants state, do you want them to bring it every time to the board, or is there an assumption that if the county has changed the zoning, that we would send you something that says that, but that the ARC office, when those things come in, would follow what the county zoning is, not what our covenants state?
Yeah. I mean, if I'm a lot holder up there and I want to sell the lot, then whoever is looking to buy is going to see, well, it's zoned for, multi-resident or commercial, probably may not be interested in that lot. So me as the lot owner, I'm losing that sale.
Well, I mean, it'll be zoned with the county as R1, and that's what will be reflected on any kind of document search as far as a potential purchase, unless the individual specifically gets our covenants and looks
They
through
did.
them.
We're actually dealing with two things right now is the reason why we brought this up, and it had been brought up, I guess, a couple of months back in a meeting with the board, but it was tabled and never brought back up. So they finally contacted us again and said, hey, we never heard back on this answer. That's why we didn't want to wait a whole nother month to figure out where we needed to go.
Yeah, a discrepancy between the county laws and our laws, the county will trump. So, there's no need for it to come back to the board as far as.
Well, in that case, then modular homes can go up.
No, because everything in Holley by the Sea is zoned R1, and we have a covenant against that.
And these are the ones that are on 399?
Correct. Yeah, they face on 3.
What's the other?
There are two. One is the seller, and then there's another one that actually had a sale pending, and he started a commercial, and then they had rezoned it, and he got notification that he couldn't do the commercial because it was rezoned the opposite direction. So.
Now, on the contrary to that, if somebody buys the property as R1 and they go through the county process to get it zoned back to commercial for that lot, then our covenant's already covered that and say it's okay.
Okay. Good. Any other questions, ma'am? Thank you.
I appreciate you spending.
Can I ask you a question about that too? If we're by county, and the county says they can put a modular on there, how can you go, if county says they can put a modular on there, but the covenants say we can't, but the county
The reason is we can't specify a usage for the property that's in contrary to the county, meaning like commercial. We couldn't say you can use that lot as commercial if the county didn't zone it R1.
Right, but if the
But
county
if
zoned.
the county zoned it as commercial, we could still say you can't, you know, if the deed for the property said that the property itself and the covenants, if it wasn't commercial, they still wouldn't be able to use it as commercial, even though the county had gone that direction.
I think what she's saying is the modular, like, you know, every home in Holley by the Sea within the boundaries is R1, is residential, you know, single family homes. But yet you or I can't clear a lot and put a mobile home because the covenants state that a mobile home can't be on that. So the use is not changing. You can put a single family home on that lot, it just can't be in the form of a mobile home. Yeah, so that, or a modular home, so that,
Okay,
does that make sense?
yes.
Okay.
State stated, covenants can be more restrictive than county, but can't not be less restrictive than county.
Thank you, good question. Thanks.
The school enclosure committee has been in this meeting tomorrow, and I'm doing
Thank you. All right, any other committee reports? Moving on to usage policy, unfinished business discussion. As noted in the last meeting, we sent this to the usage policy that was drafted and approved last April, I believe. And
Yes, April 2015.
there it is, now I was getting lost in this. Okay, April 20th, and according to this policy, it would expire at the end of this year anyways, but according to the attorney, we are able, because we are fee simple owner of common areas, we can adopt rules and regulations such as this usage policy. There were some questions with regards to the way it was written as far as the suspension and non-usage for those who are not in good standing, so he made recommendations to that. My recommendation for this is, instead of us, the board, stating who can and cannot use the facility, is just to simply put a number on the lot. And as far as showing driver's license, government issued ID, voter registration card, all of that, in lieu of that, have if it's a lot, if it's an owner, they bring their deed and a driver's license for verification that John Smith on the deed is John Smith on the driver's license, and they are within that home. If it's a renter, then they have to bring the rental agreement, just as they would now, you know, a transfer of usage rights from the homeowner to the renter, and ID to verify that they are who they say they are. And then that takes us out of the defining job, if you will. So my recommendation would be 7. Now, there are those who would argue, well, that would be max capacity. But this facility, in my opinion, since it was built, has never been able to meet max capacity. If every homeowner or lot owner in Holley by the Sea decided to use this facility, it would be too small, because there are 4,711 lots. And if everyone who, per the covenants, came and used it, we would be bursting at the seams. So I'm pretty sure that it was probably built with an understanding or a thought that, you know, 10, 20% the homeowner or lot owners would use it. So my number at 7 allows 2, you know, like your average home being 3, 2 per home, 2 per room, plus an additional. Then it is the homeowner who will provide who within that home will have the usage rights. So if it's the husband, the male and the spouse, or whatever the relationship is, if it's and then there are 3 adult kids and 2 younger kids, their adult child who's disabled, maybe not disabled, whatever the case is, that's for them to use. And then that person comes in, gets their ID card, they would still be authorized, their 30 guest passes. But it's simple. We're out of the business of defining a marriage, a relationship, an age, a disability, and it is on the owner or the renter. It's putting the onus on them. So that would be my recommendation to just, and it just gets rid of most of this, and it keeps it simple.
I haven't seen what,
So I didn't want to write all that. I didn't want to rewrite and then come before the board and say, y'all say, no, we don't want to do it. So if that is something that the board, wants to move forward with, I can redraft this, and it would be much cleaner, and it would still have the verbiage with, if someone's not in good standing, then that, obviously, those would not change.
well, if he has some suggestions, I have not seen them.
There, where they were, the red, that's where he.
Just that.
Mhm. And he had within his email, longer explanations.
So this is saying that any adult, if my son decided to move in with me, he can come use the facility no matter whatever his age is?
If he is living within your home, but you would have to put him as that, yes.
Now,
And he would have to be, he would have to be obviously.
And his driver's license would have to list that address?
No, and the reason I disagree with having a driver's license is because there are military members and there are people who have residency not here who rent, and they don't want to give up. For example, when I was in the Navy and then my husband, for 20-some years, I lived in the state of Florida maybe 5 of those years. So when I lived in California, or Virginia, or Tennessee, I didn't want to give up my Florida residency. So even though where I lived in those states, that was my residence at the time, I was not going to change my driver's license. So that to me is, I think, a bit too much to ask, so the driver's license would be for identification purposes. And then you've got your deed or your rental agreement.
I don't see why, and I don't know if that's what you mean, that people who are already established as the owners of the property don't really need to dig out their deed.
No, I mean, like for me, no, this is not going to affect someone like me who already has all that established.
This would just allow
This would-
you or I to
Yes,
go in.
this would allow someone like the former board president Alex Crawford to list her adult daughter as a user. Because she would have so many, she'd have the number, and then she's listing her daughter who lives with her as a user. And if she had 10 other members come and live with her, well then she would have to decide, or whomever it is, but that would be.
But they need to certify in some manner that they are actually living.
If you wanted to have them do a certified letter or a notarized.
Well, no, that's fine.
What do you mean? The people that they list are actually living
Well,
there?
yeah, you don't want somebody whose kid lives in Pensacola to use the facility either.
No, I understand,
So all-
verification that they
well,
live there.
All I'm saying is that owner could sign a piece of paper that says, I certify that this person lives with me.
And that could be on the form, that when they list the names, it could be,
Yeah, okay.
the verbiage could include these.
Actually, when you do that, the residents applying down there, the facility, you're listing out
Yes.
who it is. You might just add something in there with the understanding that those people live there.
Yes. And that would be, but I didn't wanna go through the time to change it if that's not maybe something.
As you might imagine, I'd like to work with you on that.
My grammar Nazi.
I would like whatever policy is come up with, that we don't do this via email with the attorney, we don't do it on the telephone with the attorney, we sit down with the attorney and make sure that we are on solid footing. Because I don't feel the attorney understands the covenants as well as the cursory reading that's been given and the advice that's been given. So I'd like to have an opportunity to pick his brain on individual covered issues when it comes to this.
I'd like you to push.
Like sitting down with the attorney,
Vote.
or drafting with the city
Drafting
council?
it, yeah, drafting it out, the simplicity of it as opposed to trying to get it overcomplicated again. And setting a number and putting a certain amount of responsibility on the family or the owner.
Pete Peters Lane, 2861 PGA. There are a number of considerations. I like anything you can do that treats owners and renters of a built dwelling where they're resident of that and how they buy the sea the same. You need to consider the owners of vacant lots.
Right.
I'm aware of at least one case from 5 or 7 years ago, 5 years ago, where at that time the owner of a vacant lot came in and said these people were renters. They happen to live over here in Lighthouse Point or Sound Retreat or one of those places. And they came in here regularly and used the facility all year. They were quote unquote renters of a vacant lot. So you need to
Yes.
fill in how you're gonna handle
Yes.
vacant lots too, and
Well,
who's certified.
yes. And we can clearly state that a renter is of a building, you're not renting the lots.
Okay.
Yes.
But we don't wanna exclude, that's been a.
No, we're not excluding the lot
Okay.
owner, but the lot owner can't rent the lots.
Right, but what about the lot owner's, significant other, unmarried? What about if there's more than one name on the deed of a vacant lot?
If they're living.
And all of those
Yes.
things, there's, and we have had in the past, people who had a residence here, or well, actually were renting here, claimed somebody was renting there, but the second or third person on the rental agreement actually didn't live in the house, they lived, like you said, in Pensacola. So, again, it would be nice to have some certification that the person is actually living full-time in the house. I don't know how to do it, but.
Well, I think if you limit it to whatever number you're talking about, because I think we try to break it down and dissect it so much. The point is, every person who owns a lot pays the same amount.
Correct.
So if they all have the same amount of people who can use it and they all pay the same amount, it
Okay.
shouldn't matter in my opinion.
And that may be the final decision. So a vacant lot can let 7 people whomever.
Right.
No, well,
access
they
to
would,
this
in
lot.
my opinion, they'd have to live with the lot owner.
But he's just saying, how do you validate that? You can't-
Yeah,
you
exactly.
gotta
That's what
trust
I'm
that
saying,
they
you know,
put on
there-
their sheet
the-
is.
Well, a lot of
Again,
them
it's a
do.
difficult situation with lots of moving parts.
You can
Right.
only put so much into the paper, and then
Yeah, I know.
you're gonna have to hit a point where you've gotta trust.
Just a couple of those issues have not been discussed so far and may need to be discussed when you discuss it with people.
Thank you. So, we're gonna move forward then with,
Is there a motion?
so make a motion to move forward with redrafting this, sitting down with the attorney. And then once that's done, presenting it to the board.
Yes, sir.
Did you hear that? Cause
I'm mumbling down here. I'm mumbling down here.
does anybody need me to restate the motion? Yes?
Go ahead.
Okay, so the motion is to draft a version of the usage policy, to sit down with the attorney to ensure that we are on sound legal footing, and then to present it back to the board for a vote. All in favor?
All right.
Aye.
So we're not moving this Thursday.
No.
So you would do 2 things at once.
And then, unless we're able to. All right, the next item is to the review of the Fun Factory. The Fun Factory is a program, let me just review it real quick, where if I wanted, as a parent, if I had a toddler and I wanted to come and work out, then I would pay the youth worker for an hour, 2 hours, whatever the cost would be, to work out, and they would watch my child. It was losing money, because whether it was one child, at the rate that it was, whether it was one child, 5 children, 10 children, we still had to pay the worker who was there. And then if I decided not to show up, we still had to pay her, okay? So we decided, because we were losing money with that, to eliminate the program. In response, there have been several homeowners or members who have expressed an interest in bringing it back. So what April recommended is that to bring it back, but under very strict conditions, and those conditions would be, it would be a reservation based only. They would have to pay Friday before 9 p.m. for the following week. There's a 48-hour cancellation. If it is fewer than 48 hours before, the individual still has to pay.
Right.
And then all reservations are confirmed Friday by 9 p.m. So she broke the cost down up to 7 kids. So if there are 7 children, then it's $3 a child. If it's 6, it's $3.50. If it's 5, it's $4.20. If it's 4, it's $5.25. If it's 3, it's $7. And if it's 2 kids, it's $10.50. And then that way, it would pay for itself. You know, we wouldn't be making any money, but it would cover the cost. It would be cost neutral, if you will. And the member, whoever wants to use this, would have to agree to these terms. And so this would be the only way that we can bring it back, is in order to make sure that it pays for itself.
So we would have them, you'd actually have a form for them with
Yes.
with the information on it.
Correct.
And
And they would have to know, and the reason why we have to have these guidelines this way, when you break down the program, what they were doing is they could call an hour before they came. You know, we got a 8:30 to 9:30 slot, we got a 9:30 to 10:30. You can call me at 7:30 or call Katie and say, I'm coming at 8:30. Well, they didn't pay until they got here. Well, if they didn't come after they told her they were gonna be here, then she's out the money because they hadn't already paid and didn't bring anybody. The other issue was, we ran the numbers of how many kids she actually had in that program on that sheet for 1 week. The numbers are so low that that's why we were negative for that program, almost $4,000. So the amount of money, they only had to pay $3 per kid. Well, if you can see over here, you need 7 kids per day to meet that, to make it flush. They were running 11 to 13 kids in average in a week. So that's why we had been losing money. So when those numbers started saying, hey, will you reevaluate it? We understand we have to pay more money to make this work. I tried to get a structure that allowed them to see, okay, well, this is what it is, but also give that department enough time to say, okay, all my reservations are in on Friday. I'm gonna email out Friday night and say, I only had 5 kids, you people who signed up. The cost for your kid this week will be this.
okay, so is it a dedicated staff to just this program? Or
They do all of those programs.
Okay,
It's
so,
the same person.
yeah.
Yeah.
So in a case like this, if we reinstate this,
Mm-hmm.
can we do this under an evaluation period?
Of course.
You know, I mean, a stated evaluation period.
Mhm.
If it doesn't say 6 months, whatever,
Mm-hmm.
you know.
We have to keep in mind though something, that when these programs were set up, she was hired in a full-time position. Full-time is 32 hours to 40 hours. If this program is cut, then she will be losing 10 hours a week. So I either have to figure out how to do something with that or have her understand that she will no longer be a full-time status employee. So that was another reason why we went back and looked at this.
But that's fine. I see that.
But I don't wanna pay her if it's gonna make us negative.
No,
So
but-
we'll have to figure something else out for that.
Yeah, I mean, the other part of that is that she's multi-purpose.
Right.
You know, she's multi-purpose down the road in 6 months.
Well, and that's the kicker with these kind of programs. I will need full-time people with summer camp because they have 80 kids.
Yeah.
You know, so to keep the staff that already know how this works, when summer camp comes and they're watching kids all day, I need to have that kind of, you know what I mean?
Okay, but that's a separate program,
Same person. though.
same person.
Mhm.
Okay, so when we get into summer camp, does this die?
No.
Is summer camp?
Oh, yes, this does die during summer camp.
Okay. So why don't we set that prior to summer camp,
Okay?
we do an evaluation on what this looks like and what it took in.
Okay?
determine if it kicks back in after
Yeah,
summer.
to determine if it kicks back in after summer camp.
Is this a motion?
Yes, I make a motion to approve.
I have a
I'm sorry. Can I make a motion? We can.
Okay, make a motion.
Alright, I make a motion to approve standing up the Fun Factory under these stipulations for a 6-month evaluation period.
Second. Oh. So all we're doing here basically is tweaking the cost to the parent.
Basic,
Right? To cover, essentially, so to cover Katie's salary.
that's
Do
right.
we have we have other costs involved.
Mhm. Okay, besides payroll, there's insurance, but the other two programs, because they're the heavier programs, from what Rhonda says, pay above and beyond for the insurance coverage, because this program
they'll
is so
cover it.
small. Exactly. The coverage covers this, but there's no reason to pull that out of this money
Right.
because the other ones do. You'll see that
That's covered financially.
exactly from the other. But this, when I did, you can see the weekly payroll amount, and then I divided that weekly number, that 147.50, into the 5 days a week. That's where I got how much that payroll is per day, that 2107. That's how I got all these other figures to figure out how many kids we have to need and what rate they can pay in to cover that $21 amount.
I think it's worth a shot if we can provide that without, without a cost.
Yeah.
Yes.
I have a question. So you're saying that for the Fun Factory, they have to, like Friday the week before, they have to have all the reservations in?
Yes.
Can I make another suggestion? If there isn't anybody and there are some openings for kids to come in, like if I bring my granddaughter, like can she come to the Fun Factory? Even though she's not a member of Holley by the Sea, but I'm babysitting. To add more money to the Fun Factory. I mean, if they're not full to capacity with members' children.
Is she living with you?
No, she's not.
Would she-
But this is just
Would she-
I mean, she wouldn't come anyway, so they don't even live near here. But I'm just
But no, I
saying,
mean, it
in
is.
general,
Will she come in under a guest pass?
yeah,
Sure,
she would come in as my guest.
sure.
So can they use the Fun Factory?
I don't see why not.
Why can't I pay for the Fun
No.
Factory to earn more money?
So for example, if there were only one other child there, would you be willing to pay the $10.50 at a drop?
For an hour? No.
And see, so that, I understand like a drop-in, and I'm not
talking about drop-ins. I'm saying if I know that I'm gonna have her all
She's
this,
saying to make the reservation.
to make a reservation,
Oh, I
as long
understand.
as the members, if they.
okay, I got you, I thought you were talking about a drop-in, I
No,
got you, okay, I
no, not a
understand.
drop-in.
So if there
Because
are
I
no
would-
members who are using it and you have a guest, such as your granddaughter, can you then call on Friday and say, hey, is there space? And we say yes, and I don't.
Yes, as long as they're under a guest pass, that's the only way they're covered under our insurance.
No, because we tried that years ago. And we even came before the board and asked the board for permission to bring our granddaughter, since we keep her Monday through Friday, and we were told no, that was prohibited. So we never used the Fun Factory.
Why did they tell you it was prohibited?
Pete Peterson was president of the board at the time. I wasn't at the meeting, my husband went, maybe Pete can tell you.
I don't recall why the board voted that way.
But you recall that the board, that.
I recall, my understanding was you wanted to come in for the whole summer, more than 30 times that your guest passes would cover. That's my recollection.
That's not correct.
Yeah,
Well, this would be.
my recollection was
No, we
that-
would not have exceeded the 30 guest passes.
Okay, my recollection was that if you wanted access without use of guest passes. That's my recollection. I
Okay, well,
have to
maybe
with
check
it.
the policy. I mean, because I think if you allowed grandchildren, if you expanded who could use it, you probably would be a lot more profitable.
Yeah.
Because
Well,
I
like
would have
said,
paid
if they're in
twice.
under
I
a
would
guest
have paid
pass,
$6
we,
today.
you know, we don't regulate, I mean, they're under our guest pass, then they're good.
Yeah.
So I don't know
Well,
why
see,
they're
we were
good.
told, we dropped her off one morning, and then the next time I called to do it, the person who was working the Fun Factory said, I'm sorry, but we didn't know your granddaughter doesn't live with you. And her parents don't live in Holley by the Sea, you'll have to get special permission from the board for her to use the Fun Factory. So my husband came to the next meeting, and it was voted 2-3 that we could not use the Fun Factory, so we never did. But I would have, and I would have paid $5 an hour.
Well,
To
the
me, it's worth
stipulation
it.
here is that it would be members first, and so like on a
Well,
Friday.
yeah, sure, that's reasonable.
Football
Yeah.
and,
Yeah, but I'm just
there's
saying, this
6
would
openings.
also help the income coming in, because
cover
once,
it.
Right.
I know a lot of the girls, when we do Zumba and stuff like that, that come in, you know, if they knew that they could do that, there would probably be more kids that would come to the Fun Factory.
Do we have a limit on
What's
the
the
number that
limit?
can be in there?
Yes,
But you're not even
yes.
close to getting to it, though.
There's
That's
seven
not,
minutes,
that's not a
right?
problem.
7 minutes.
Yeah.
No, but, it depends on the age group, so if they have any kids that are, between 1 and 3 years old, they can only have 5. So we couldn't do it unless they paid that amount, see, because of the DCF requirements. Now, if they're over that age, she can have up to 12.
Right,
And
but when
she
you
basically-
realize you only have 11 kids in a week, you're not even close to hitting it.
Right, cause this, we're talking about daily, I'm not talking, yeah, so we're
Yeah.
just talking about,
At a time. All right, so make a motion to move this to Thursday. All in favor?
Aye.
Aye. All right, under new business, the Catsman Garfinkel past assessment collections proposal, so we can have,
January 23rd.
so we can have a discussion. I make a motion to approve the hiring of Catsman and Garfinkel for the purpose of assessment collections.
Second.
All right, so discussion I did before he left, he said that he would waive the retention fee and he would also cover the cost to have the Comcast with the television installed, and it would have to be in a secure location, because they would be discussing legal issues in the general manager's office if we were to, hire them. So the retention fee is only $150, but he would waive that plus the cost to start at the Comcast, which is the ability to have, video.
Now, we're considering this only for the collection aspect.
For the assessments, yes.
Yeah, cause when I look
Collection
at,
of
when you
assessments.
look at the package, it's a whole package,
Mhm.
but, yeah,
That's their ultimate goal, is to
Yeah.
become our attorneys.
yeah.
But this, we're looking at only the collection factor.
And I do like the fact that they're, for us, you know, everything's a cost benefit analysis. You know, the cost to us is really, as an association, nothing, because as he stated, the interest and the late fee is not really counted as income. And so that goes to them where we are, number one, reducing the bad debt, and number two, increasing the assessment collections, which does help our overall budget. So it's really, it does seem almost too good to be true, but this is a model that they've created, and, you know, I think if we can benefit from it.
Kevin, do you see any way that this can tie into what you and Pat and them are looking at, or Ms. Pat?
I think it would need to be discussed with the attorney more to find out, because it sounded like he had some pretty definite thoughts on that.
We had some reservations about it.
Yeah, so I'm willing to further talk with the attorney about that, yeah.
It sounded good.
Yeah, I mean, it sounded like to me that they had something that dovetailed,
Yeah. As far as letters and,
Yeah.
Yeah.
With the forms that could be
form
used.
and the finding process, if you will, putting it into a more concrete perspective.
Pete Peter Zane. The plus obviously is they're working on a contingency model, no risk of the association. My questions are, aren't we up to date with demand letters and liens? I thought that was an automatic process after, 90 days passed.
Yes, we're sending them though. We cannot as an association file the liens ourselves
No, but you
legally.
send the demand letters.
But we're sending a demand letter from here. I think the point is if they get a demand letter that's from a lawyer, it's a little bit different than getting a demand letter
So we're
from.
sending a demand letter
We're wasting
that
paper.
costs our members
That's right.
very little.
Well, it's not just the demand
The-
letter that's being sent, Pete, it's
Right,
also, we don't.
I understand,
For example, there is a case where we looked at just in the last 30 days, where the demand letter was sent, and then the attorney said, do you want us to move forward? Now, the assessment it was far less than what we would have been charged.
Agreed.
So it's, do we spend more to get less? Where this
But
takes
rather
care of-
than add $170 to what the delinquent member is going to pay by having this lawyer send out the demand letter, because that's gonna be added into what he's gonna collect from them. We are legally allowed to send out demand letters, not liens, but demand letters.
Well,
We-
if
we
we
have.
have assessments that are 3 years old,
Yeah.
demand letters have been sent, we've not gotten anything, so now, again, it's one of those, do we
I
spend
agree.
X amount of dollars to get Y, and that's where he
Well, but
comes in.
the next step is, and haven't we filed liens on all the delinquent ones? Cause that was almost an automatic thing, I thought, haven't for the last couple of years.
No, we do have liens on some, okay, but because it is a legal procedure, especially over the last, I would say, year, we have not sent them.
Okay, cause when I was on the board, we were cranking out the liens.
It'll cost us $375 to get a lien placed on an assessment that's $425.
Yeah, it's true. But
So no,
at least through my board, we were filing the liens also.
Well, we
And then
have
hoping
not.
to recover them.
In the
Okay,
last
have
year,
not,
we
okay,
do have
so they're not up to date.
No, some are, but what her point is
Right, not all of them.
they were looking over the last year, so last year's assessment was
Right.
345.
47.
So are you going to spend $375 to get 345? You're at a loss, and
Yeah.
that makes no sense.
Well, no, you're ahead, because if you collect it plus the legal fees, so you're not at a loss if you're successful.
Exactly, and
Right, okay.
where that risk is
Is going to
removed.
the lead,
Yes.
the lawyer. And he brought up the borderline, the Greenbelt properties,
Yes,
that's off the table.
that's a separate issue.
Yes.
That's
There's no
okay,
need to
good,
go
because
into
we've got
that.
our own lawyer to
Board
deal with
yes.
that. And okay, I guess he answered why the current law firm can't do the same, because they won't work on the contingency law.
No.
Exactly, okay, thank you.
Why isn't our lawyer doing this?
They
Yeah,
would, but
because-
they're gonna bill us.
Yes,
They're
like
gonna
they
pay up
just,
front.
in the last
They're
30
gonna bill
days,
up
they
front.
asked us about a case. And they said, okay, moving forward, what do you want us to do? If we move forward, this is what it's gonna cost you. And they were upfront, they said, look, what it's gonna cost you is more than what you would get. So it's really not financially conducive to move forward, so we've done this, but to go any further is going to cost you more than what you would be able to recoup. So that's why we're not using it.
But this gentleman here is charging his lawyer fee to our member.
To the member, yes, who's late.
Why isn't our lawyer doing that? Why can't our lawyer charge that person?
Because as he said, there's a process that you go through, and you could get to the end where in mediation, just so you can get the assessment, you're saying you're agreeing to, okay, we'll delete we'll delete the late fees, we'll delete this, we'll delete,
Only if they go to mediation.
only if, yes, but if a homeowner, if they wanna do that, then we're stuck. So he is bearing the cost. He's bearing all the costs, and if the homeowner still says, you know what? Send me all the demand letters you want, I'm not paying you. We're out nothing. So if it costs him $500 to get to the point where the homeowner says, we're not paying, we put a lien on our home, we don't care, we're not out anything.
Did we check into collection agencies?
A collection
Yes,
agency?
why
No.
can't it go to a collection?
Because we would have to pay a fee. No doubt a collection agency is not going to do that for free. So
But
we're getting.
they would get a portion of what they collected, like he's going to get a portion.
No, he's not getting the assessment.
Right, he's not getting
He's
the
getting
assessment, but he's
the-
getting all the late fees
He's getting
that
the late
occurred
fee
and all the interest.
and the interest, which is
Correct.
not considered income. So
Well,
we're getting we're getting what is considered income, and he's incurring legal fees, and the homeowner, who is delinquent for 1 year, 2 years, 3 years, whatever it is responsible for that. And that's why I asked him, is this a, legal fee per, and, based on his answer, if you're 3 years behind, you get a letter, and you're charged for that. You're not charged, like, say, $200 per year. So it would be $200, you pay it then your additional is $200, and that's it. Plus your late fee interest and.
I still think we probably need to look into a collection agency just to see what the costs are. I mean, even with the late
There's
fees.
no cost to us here.
I understand that.
No,
So-
you're talking
so-
about cost of the collection agency.
Yeah.
As something in comparison.
Yeah.
But on the other side note of that, we can do that, but I think because he is an HOA, this is what they do, the legal backing and the liability, he has way more knowledge about that than a standard collection company would have. So I think that's why it was one of the things that we were looking at, is just because they are an HOA law firm.
Have you used these guys in the past?
I haven't, no.
You haven't? Okay.
Mhm.
I'm also familiar with 720, as he said, that, 720 is used
I
in
just think-
mediation.
And how did you guys find this gentleman?
I actually found him when we were first on the board. I was going through a training that I paid for, and they were a part of that training. And I did some research on them, and I just sent them an email. They sent me back a couple little things. We had then, at that point, decided to go with Becker and Polikoff. I thanked them. They reached out to April just to let her know that, hey, I had talked with them. And then at that point, they sent the information of what they really do. And to answer your question on the collection agency, I think, we can look into them. But the problem you have with the collection agency, not all of them do it in a proper form. So it's a liability if you have someone on the collection agency who doesn't follow the law, letter of the law perfectly. They compromise us, where a law firm is not gonna compromise what they're doing. They're not
The
going to
liability
use
is
scare
not the
tactics,
law.
they're not going to do anything outside of the law to regain their money, where
How many
some collection
delinquent accounts
agencies
do
do.
we actually
What was that number you said
We are, I think, I'm gonna give you a safe number.
have? Not for this year, just from past years. 'cause
Okay, well,
this
we can
one-
only go back 5 years.
Okay.
The statute of limitation only allows you to collect within that 5-year period of time. So we did go back to 2012. And we are right around 350 lots.
Wow.
We are
18%.
actually,
We are 18%, about 18%.
right, so if we were to look at the total amount that we're owed right now, it's about $150,000. So if they can, and that's only on the assessment portion, that's not late fees and interest. Late fees and interest are about $90,000. So if they're taking 90 and we're getting 150, or an average of that, obviously it's not gonna
But
be
just getting the
100%.
150 is.
Right.
A lot.
Is more than,
For 80% of it.
Hey, that'll pay the pool down.
yeah.
So it's a little bit more than I even thought, than I thought the number, and so that's why I think if it's no cost and they can get 50 or 60% of it back, even if it's just the assessment, I personally, that's our goal anyway.
And where are they from?
Fort Lauderdale is where he's from. They have one in Fort Lauderdale and one in Orlando.
And I think the fact that he came up here for a night, obviously he wants our business, so that's part of it. But I think that does say something, and he seemed knowledgeable based on the way he was able to walk through a process. He's knowledgeable with the law, how it's done, so that to me was, and obviously with the book that he gave us, we haven't had time to
Just the fact that he has to get paid in order, we have to get paid in order for him to get paid.
Right.
we have to
Is,
pay them.
big thing. I make a motion to move this to Thursday.
A second? In favor?
Fine. Thank you for the questions.
Okay, so the next item is here is on the water. Kelly Smith, he is a homeowner here in Holley by the Sea, he's a member. And he sent a request to bring 2 plastic kayaks into the lap pool to conduct tours on the water kayak safety training, like they did last year. They only used 2 lanes. if anyone's not familiar with Heroes on the Water, they're an organization, nonprofit organization that works toward helping wounded veterans get back out on the water. And if you've never been to one of their events, I would encourage you to go. It's an incredibly moving experience to see these wounded veterans, and some of them who are paralyzed, be able to actually get on the water and feel independent again. So he will use his guest passes for all non-Holley by the Sea residents. We'll coordinate the best time to use the pool so as not to interrupt anyone who's looking to use it February 16th and 18th. So I make a motion to approve this request.
Second.
Any discussion? I make a motion to move this to Thursday.
Second.
All in favor?
Aye.
All right, the next item is a discussion petition for requesting a stop sign speed limit change request from a member. The member is Patricia Hoog, and she's going to present the findings. Thank you.
Hi, Patricia Hoag, 2792 Camden. Can you hear me? I've also brought with me a new member of our community, Van Jones. He has property at Leisure and
Leisure in Camden.
in Camden. And he is also in favor of reducing the speed limit on Camden and stop signs. And I'm asking for stop signs every other intersection, which is equivalent to our blocks in our streets. Say a street runs from Edgewood to Sherwood, there's a stop sign at each block, so that would be equivalent to every other block, every other intersection. Camden, in speaking with the residents, has been known for reckless driving. I got a report, a crime analysis report from my 11 streets that run along this one street. Unfortunately, it wasn't divided by just the homes that touch this property, the properties that just touch the street, but there's 2,700 calls made to the police in just these 11 streets.
In what time period?
In a 10-year period. I'm going back 10 years. According to
Can
my
you repeat that again? You said there were 2,700 calls.
2,900 calls in 11 streets that connect with Camden from 2005 to 2015 for incidences of needing calls. Of those calls, Camden has 93 reckless driving calls. In that 10-year period also, within that 93, there's 135 calls made for other problems.
Now, these are calls initiated by members?
By members. I have 62 pages here of calls. And I am going to do further, I could ask for another report to just list these per homeowners on Camden. So that's another report I have to go through, and then I have to pay for that information. It is just, and we are also asking to reduce the speed limit to 20. There's 25 miles an hour now, with one stop sign for 4 miles. I've gotten 27 signatures. 2 of the signatures are an additional signatures from the same homeowner, another homeowner in the home. To my knowledge, I only missed 4 actual homes that touch Camden. One was a renter, so I didn't think they counted. 3 did not answer the door. One actual homeowner also is our prior president. I don't know if that's why she did not answer the door. But I think that's a good percentage to have this done.
How many did agree?
Excuse me?
How many did not agree?
One guy said no, another guy said he wasn't interested, and then I think I missed one. and then one didn't answer the door.
Now, do all these people, do these properties touch Camden?
Yes,
Physically touch Camden?
yes. They have road frontage on Camden,
Frontage on, or side?
side, front.
Let me say first that I cross Camden frequently. And my concern is always that someone will come flying down that hill road and not stop.
They
Now,
don't,
what's that?
they don't even stop at the stop sign.
Yeah,
that's
right,
all.
I know,
Yeah.
I know. Now, I've spent over 30 years in law enforcement, and I see no connection whatsoever between stop signs and this list of offenses that you have here. Criminal mischief,
No,
property loss missing,
correct,
vehicle theft.
correct. The list that I requested was based on conversation with homeowners. Homeowners are saying that they're receiving property damage from anyone that uses this road as a NASCAR, dirt track, transportation street. I personally have been vandalized. My property has been driven through, not just on the right of way. They came into my property and did property damage. We feel there's another phase to this, trying to get this under control, and that would be paving it. That's another phase that would not include your decision. It includes a big majority of the people that live on that Camden have said yes to that. The decision I'm asking for you, with more support that I get from the Sheriff's Department, is to prove that these people have called and said, this has happened to me by living on this street. And yes, they will fly through the stop signs, but it will slow down the people who choose this road to drive through if they have to stop every other intersection.
It'll slow them down, yeah.
Yeah.
But again, I see no connection to these other things that you have listed here, and this doesn't make a case to me. What would make a case to me is how many vehicle accidents have there been, how many T-bone crashes at the intersection, how many cars spun off into the ditch, and that sort of thing. Because we're looking at a traffic issue.
Correct.
We're not looking at felonies and
yeah, some of these
vehicle burglaries.
family disturbance were all added in my request. I felt that some of the items that I requested were based on conversation, what I've heard from the neighbors.
But when you provided to us tonight, the 2,900 calls between 2005 and 2015, were the 93 dealt with reckless driving, and the
just on Camden.
Okay, and the 135 were other driving. So that number of the 2,900, the 220 some, those were driving related calls made from homeowners who live on Camden or intersecting roads
With
to
the words
sheriff's.
Camden in the report.
Yes, to the sheriff's office.
Right, now there's, the side streets, there are also, reckless driving, complaints, but I do not have the addresses of that person that called.
Most of those have stop signs.
Excuse me?
Most of those side streets coming at Camden.
They all have stop signs on,
Yeah.
to Camden.
I mean, you know that I drive it, so.
I see it.
I mean, yeah, you see me coming down there. My thing on Camden, as a whole, is I'm not gonna drive overly fast on Camden. Number one, it's rutted, as a general rule. Sometimes that's thanks to the mudders, or the school buses, which I've seen out there. But I've had more opportunity to get hit from the side streets, from the people that don't even stop at the signs. I've had at least 5 occasions where I've had to stop, and you know, either trucks or even residents coming out of their garage and just shooting by 'em. So.
Because most people think you're gonna have to stop because you're on a dirt road.
Yeah.
I mean,
Well,
that's
we feel,
unusual to me.
why, if the side streets have to stop, why can't Camden also have to stop more than once? On, was it 4-mile stretch?
So, obviously, we don't have control over the road or stop signs. I mean, you're just basically asking, I mean, you've done all the research, you put the package together, you're just basically asking for the board support in your presentation to the county in getting a stop sign.
And reduce speed limit. Now, they might give us the stop signs. I understand that people on Edgewood asked for stop signs, 20.
Well, see that, and what happened there, and that's where the difference is, it wasn't the homeowners, it was the homeowners who came to the board, and the board agreed to go before the county commission.
Oh, on Edgewood?
Yes, and that was not just Edgewood, but Citrus, there were several throughout Holley by the Sea.
Okay, I didn't know
That process only added 12 four-way stops
Yes.
in the entire
Yes.
Holley by the Sea.
And some of those
Only added
homeowners were
12
present
stops.
when Pete, you know, spoke before the county commissioners. But having this with the board support lends weight to the request, if you will.
Yes.
Yes. So, you know, and what they would do based on what they did last time is they would probably do a study and determine if, you know, every other one is best, or maybe 2 are best. They would come back and say, we'll put this many in. And I know that the last process, the board came back and said, well, we would like a couple more, and they were said, okay, and so they did add more. So I make a motion to approve, this request with the intent of taking it before the county commission or Roads and Bridges Department and the county commission for action.
Second.
Discussion?
Any other streets that require the same thing while you're at it, Palmetto?
There was another street that a member asked, and I reached out, per his request to Steve Furman, who then reached out to the county commissioner, and the county commissioner said no, and Steve Furman said the first thing that he recommended was to do what you did, is that this homeowner, if he could get 60% of the people who lived on that street to sign it, and that's a much busier street. It's Coral, the east entrance, then that would be something, and then he could bring it before the board would approve it, much like what happened in 2012. So that's the only other street that's been brought to our attention that I'm aware of.
I guess in my mind, I would be willing to let the county look at it, but I'm not in favor of that many signs, that many stop signs.
Well, I feel that you, are an exception to the rule as far as driving down that road. And I will do my best to, get some more reports in reference to driving. Like I say, all I did is.
I'm willing, like I say, I'm willing to let the county look at it.
Right.
And if the county says, yeah, that's something that, you know, makes sense, you know, I understand that. I know what you're talking about. I've even tracked down some 4x4s, you know, and a truck with a flag on it one day that damn near ran me over when I was out there walking, you know. So I do want.
My husband runs that almost every day, and he comes home and said he almost got hit 2 or 3 times because even with that stop sign there, because they just go right through the stop
They go
sign,
right through the stop sign.
and he's running across, and he said, if I didn't stop, that guy would have hit me.
Yeah.
There's children too.
Yeah, and
Children
there
on
kids,
bicycles, there's
yeah.
children walking,
Camden gets-
there's adults
yeah.
walking animals,
Yeah.
all subject
Yeah,
to.
and I walk the
all
animals,
subject
I'm out
to
there,
harm.
I know that, and there's also kids on the ATVs.
Yeah,
Exactly.
yeah. There's a
So,
lot
I
of
mean,
kids, a lot of people out there that run that
yeah.
road.
That's another issue. The county, said that, or the police department said that they can drive their ATV on a dirt road, however, they must walk it over the asphalt, which they don't. That's,
There's that.
You know, they fly.
Yeah.
They don't touch the asphalt, they fly.
So make a motion to move this to Thursday?
Yes, that's thank you.
All in favor?
Thursday for a vote.
Yes.
Thank you.
And then you and I can get together and we'll get a package of relevant information together. and
Okay, good,
present.
good, thank you.
Thank you, position. And board and members for comment. The next issue on the agenda is the Holley by the Sea peer rebuild issues with contractor. So we approved the contractor in October. And the thought was that they would begin within 30 days. They said they could begin at the beginning of January due to other commitments. We received an email stating that after we called, I know that I left a message, April left several, and they finally got back with us and said that they could not start until the end of March, April timeframe. So we looked at the other bids, and I will make a motion tonight so that we can discuss it on Thursday, but I make a motion to approve the bid from Cajun Contractors for $72,185. It's a 5-year workmanship. They would be able to begin January 21st, and it would take 4 to 6 weeks. The cost that's my motion.
That's second.
So the cost in relation to Alfred and Sons, their price would have been $66,650. Shiloh Marine Construction would have been $80,600 for a 1-year workmanship, and then Pierce Plus would have been $88,879 for a 3-year workmanship warranty.
Where did you get the warranty?
Front page.
Where do I not see that?
Now, on the previous bid that we had with Alfred and Sons, we had the 66, but we had a contingency in that up to 70.
Yes.
In case we needed to replace some piers, and it looks like this one for 72 also, it includes replacing the piers and not just repairing the ones that need to be. So we're only a net $2,185 for what we've approved.
There was another that addressed replacing them, but it was higher than this.
Yeah. So does this include handrails down both sides, or is it only on the one side?
Top, middle, and bottom row.
Okay, so yeah.
I think both.
Yeah, it's on both sides, it sounds like.
No, it's 2x4 standard pressure treated top, middle, and bottom row.
But I thought it was both sides.
It looks like it is. It says around perimeter.
Yeah, 'cause that's an important part for us.
Yeah.
Gotta make sure it's both sides.
You're only looking at a $5,500 difference between the one that we accepted and this one. And you're looking at starting in the next couple of weeks.
The 21st,
Next
I believe.
Thursday.
Next Thursday.
21st.
Okay, so any other discussion? Make a motion to move this to Thursday?
Second.
All in favor?
Aye.
This next one is just information process, or information purpose, is to review bids to select contractor for parking lot, roadway retention pond enforcement, walking trail projects, alternate source of water.
Actually, we won't get the bids until
Yeah,
Thursday.
Thursday.
Yeah, it's just information that they're coming in.
Right.
We'll just talk about that later.
All right, this next one was added, the review proposals for modification of the recreation center for accessibility. This was discussed at the last meeting. We had asked, there were 3 bids, ECL, which is a all-inclusive company, so their cost was much higher. And we asked them to break it down to be more comparable to BECI and RJH. And they essentially said that they don't do that, that it's all or nothing. And so, it's nothing for them.
So we're down to.
So we're down to BECI and RJH for conceptual drawings. So we were able to meet with, what's his name? Jimmy Fell. Ron and I did, he came out and I thought he was knowledgeable, and so I would make a motion to approve BECI for the conceptual drawing.
And what's the cost on it?
The cost, the conceptual design is $16,000, and then an executed copy of this proposal, would be required to scheduling any services and retain a fee in the amount of $500.
And what does this give us? Just pretty drawings?
It gives you 3 conceptual drawings of the facility based on the walkthrough that we did.
This is what we want, A, B, or C. And then everything else, the way it seems to me, would be developed to support that, much like with the back 40.
Just let me clarify, let me send them an email, but from my understanding of the walkthrough, they were gonna do these designs, and because they're engineers, they're engineered stamp on these, which tells me that.
Well, no, that actually, if you read further in that paragraph, it talks about once we decide which one we wanna go with, then they put that together.
Right.
Okay, but the thing would be, is that part of the cost? The overall cost is that, that we're paying for, to start with. In other words, 3 concepts, 1 set of specs. And the other part that I know we're talking about the fair housing stuff, but where does fire suppression?
No, we've been through I've been through the fire suppression conversation with all of these. That is totally separate. We actually, Yvonne was in my office and we were trying to track down who to get information on this system. And the, what is he called from the fire department?
Fire marshal?
Yeah, the fire marshal is the one who would come in, and they basically said, we do not tell you, that you have to have these systems in place unless you are, we cannot tell you have to have it until after you show us the plan. So he said you would have to get the drawing from the engineer and submit it to the fire marshal, and they review it to tell you what kind of system you have to have in place. So they can't even tell us what kind or how much until we get these drawings done.
Okay, but can they work off the conceptuals? In other words, if we give the fire marshal all 3 sets of conceptuals, could they take a look at that and let us know if in fact we're going to need fire suppression or not,
Yeah, I would think so.
because that would be, I think, a factor potentially in determining which way to go.
I think we're kind of getting ahead of ourselves with the fire suppression. It's definitely a serious topic, and I understand. But before we even approach that, we have to kind of know what we're going to do. Because if we don't change any of the hard structure, if you will, then it's almost a mute issue. Does that make sense? So I think
Well, no, I know that. What I'm saying is in relation to that next drawing, in order to pass the result, to give us a set of is it possible that the fire department would look at it and say, okay, we can look at the conceptuals, so we don't turn around and we pick one, and then they give us all the nice specs. And we turn around and find out, no, this isn't gonna be, it's gonna be cost something.
Well, I don't see why the fire marshal would.
Be able to look at design.
I think, when we first started this idea, I thought and still think it's a really good idea. But I have to wonder now that we've run into so many issues with the dome, with needing a replacement blower if we keep a dome, possibility of a new dome, a new pool deck, which even if we build a permanent structure, will need replacement. And with the possibility of all those costs and the engineering and construction costs with perhaps putting a permanent structure on it, I'm concerned about the advisability of spending this much money on this concept right now.
It's funny that you mentioned that, because April and I had that conversation before the meeting started when we were talking about this, and one of the things that we did talk about is these issues, that everything that you just mentioned. At a minimum, what I would like to see is at least a proposal for accessibility.
I agree with that.
And then they might be able to look at the pool dome and the chairlift for the pool and those other things. So instead of this, you know, what we discussed, you know, kind of a more comprehensive, if we can make a list of the priorities and get those and items first. Does that make sense? Am I saying that right?
Well, yeah, that would require another estimate. Yeah, I'm much in favor of that, so, the accessibility issues. But as far as the comprehensive thing, I'm a little weary right now.
So is it possible to still move this to Thursday, but go to him and say, look, if we wanted to limit to what we discussed, what we're wanting to do, does that change the price any for the conceptual drawing or?
We add in, and we add in those items.
We already discussed those things,
Yeah,
not with the
they're
exception of the pool dome, but all those things we did discuss
On the-
within this, yes. But instead of more comprehensive, taking into account the things that have come up, kind of
Yeah, no,
reducing it down a scale, if you will.
a la carte.
Yes, pretty much, it would probably have to be that. I mean, because the original idea that we had would, in essence, modify the entrances so that this side of the building was closest to the parking lot. That's obviously gonna cost quite a bit. But if we could say we were gonna cut back the kitchen area, and instead of cutting it back right now and do nothing, maybe we made a unisex, a handicap accessible bathroom in that area, and then get our push button doors for them to come in and modify this entry gate. At least we would pacify the access issues until we decide to move forward with actual structural, footprint changes.
Right, I agree with the focus on the accessibility.
Right now, you're hanging out there with us, that could be mine.
Go ahead.
Well, can I make another motion?
Okay.
I make a motion to go back to BECI and request a proposal based on
Accessibility.
accessibility needs, and the pools as well. Alright, make a motion to move that to Thursday.
On.
Second.
Who seconded that?
Ron. Alright, open forum, membership discussion.
Tricia Hall, 2792 Camden. Last month you had spoke about the Navarre Water getting involved with this overflow with the lakes out front.
Yes, they came.
Oh,
They're awfully full right now, and you don't seem to have that on the table to talk about it. Did they give you the,
No, what we
results?
approved is that they can move forward with the,
Geotesting.
the geotesting.
Oh, geotesting. Is there any way to lower the water level of those now? Because they're very high.
They are. They are, but there's a reason why. They're doing different structural things under the ground now, and the issue that we're having are a couple different things. One of the main things that came up last week is the pump and, Lord, I know it's gonna leave me. Special term for something that pumps that water in over there besides our normal pump. They have to replace it because it's done. So they have ordered that because it's their maintenance cost to do that, as well as we had to order a part for our side. So that's why nothing's happening over there besides the aeration at this particular point in time. And also they're putting additional piping under already to make the pipe bigger right at those two entrances for the pond. We've seen the trucks over there probably last week and the week before, maybe, okay, they've been in the mornings. So they're doing work there. When they're doing work there, they basically shut everything off, and when the rains came, it filled up, but they haven't done
They
any.
haven't added more water.
No.
Okay, thanks.
Peter Zane, just a couple of comments. You're talking about adding cameras to architectural. We already have them in accounting.
Yes.
Okay, because that's where there was a couple of issues over the last 5 years.
I think that's why they put them in there, was because
because of a couple of issues over the years. You mentioned tree replacement in spring. If you go to all the IFAS, Institute of Food and Agricultural Sciences, and the extension, spring is not the best time to plant trees
I
because
was just throwing out, not right now.
yeah, I
haven't
got
looked
you.
into-
Because it's very hard to keep up with enough water during the summer. Best time to plant trees is fall and winter. Just
And we need to use something besides Bradford pear. I said we need to use something other than Bradford pear.
Yes, Bradford pears don't hold up well, they're very brittle. Status, 2015 audit started?
Yes.
Good, okay. With the change of management, and
We're actually
are we with the same accounting company though?
Yes, we are.
Okay.
Conrad Senior, we're well underway, as a matter
Okay,
of
good
fact.
enough.
Probably next week you should be seeing some.
Yeah, like I say, there's like a 90-day deadline or something like that. Speaking of which though, status of a more current reserve study.
I'm supposed to receive my draft by Thursday this week.
Okay, for the draft for this year.
For 2016, yes, sir.
Yeah, which is usually, okay, gotcha. And, any further movement on the board on selling our own lots? I would sort of highly encourage that, because we're losing assessments and we're paying taxes on, was it 3 lots? We're foreclosed on and we own. We've owned them for years, we sat on them because of, the real estate downturn. Well, the real estate downturn is no longer, so I would highly encourage the board to consider taking whatever our 3 lots, getting them on the market. Huh?
Maybe we could just demolish them and turn it into parks.
If that's, I guess that could be done.
Since we own, we don't have to go through the county, we could just.
Well, yeah, except you'd have to get a zoning change. It's possibly doable, but whichever, we have other park designated areas that are already designated as parks. And those are 3 lots we could be collecting assessments on and not paying taxes on.